Good afternoon, everyone. Thank you so much for joining us today. We're here to present a webinar on the various facets of Shareholders Agreement, presented by our Managing Partner, Mr. Sumesh Devan, and myself. I'm going to present the PPT in a while. I'll request Mr. Devan to say a few words before we start.
Yeah. Hi, everyone. This is Sumesh. So we're going to be discussing about Shareholders Agreement. So typically a shareholders agreement is something which is not structured or which is not a defined terminology or something like a regular contract, and it's an optional contract. So typically once a company is incorporated, because in the interest of usually the initial promoters or investors who invest in the company and follow the procedures laid out in the Companies Act. But many a times what happens is we as legal counsels always recommend the initial promoters or the investors to have a defined shareholders agreement. The benefits of having a shareholders agreement to per se is you have a defined part. You are aware what you're going to leave in terms of your shareholding in the company, future dilutions, your powers, your rights in the company, and and specifically more so it's become very important this day and era with the advent of most of our companies being investors acquiring minority stake ranging from 10 to 15%. So typically our Companies Act doesn't give too many powers or doesn't especially to minority shareholders. It's always been lopsided and worked in a way where the majority shareholders have a controlling interest. What a shareholders agreement does is it provides powers to the minority or each shareholder. So someone holding equity as lower as 5% or 10% or can define that he would have a right to appoint directors, certain information rights, or hold or even have in case going future he can get the promoters to buy back his shares or have some specific provisions. So from this point onward, I'll ask my colleague to Tanya. She will present the PPT and they can give us specifics what constitutes a shareholders and what clauses and recommendations we have, what should go in or formulate part of a agreement.
Purpose of a shareholders agreement. I think like Mr. Sumesh Devan correctly said, adding on to the same, that a shareholders agreement, like the term suggests, it details and elaborates on the provisions and everything to do with the shareholding pattern of a company. So why is this imperative? Because it gives the minority shareholders, the minority shareholders, the majority shareholders, everybody a right to be able to negotiate and get their rights intact and enforceable through this agreement. Because like he also correctly stated that the Companies Act is very limited. So going beyond the regime of the Companies Act, the shareholders agreement has been structured and placed in such a way that everybody who's going to be a shareholder in the company, be it a minority or majority, whoever gets a right to negotiate and get their rights intact and protect their stake in the company wherever they're investing. So a need for a shareholders agreement is simply that it's very, very imperative to protect both the business and its shareholders. Why the business? Because if we are running a business and there is no clear demarcation of a decision-making entity or a entity exercising powers. So basically, if we have a company, we're running a business. The business also, it needs to be clear who's going to be doing the decision making, who's going to be a part of the functioning, the daily working of the company. If there is a mess over here in this aspect, then definitely it will detrimentally affect the business as well. So it's very important to have a shareholders agreement where everybody, along with their rights, also know their roles and responsibilities towards each other and the business. Whatever they bring to the business, those roles and responsibilities are also very clearly demarcated in the shareholders agreement. So that makes it even more imperative to have one in place. So like it states, a shareholders agreement is created with the purpose of protecting both the business and its shareholders. It ensures the shareholders are treated fairly. It can also be beneficial to minority shareholders who usually have limited control over the business operations. Looking from the perspective of a promoter, it delineates duties of shareholders and powers in respect to the shares being held by the investor. It predetermines the functioning and procedures to be followed by the promoters. And from the investor's perspective, protection of investor rights like representation, protection from possible misuse of investor shares, prevention of acts by promoters contradicting to principles of natural justice. So these are some sides why we at the first place need to get into a shareholders agreement. Moving on, cases in which shareholders agreement is signed. So like we mentioned and we've given a background about why a shareholders agreement is important. When is it signed is of course when a company is getting restructured, either when two companies are getting merged together, or one company is acquiring another company, or two parties are coming together to create a new company as a joint venture company. These are some instances when a shareholders agreement is signed because the shareholding pattern of either two pre-existing companies is being restructured or a fairly new company is being formed wherein the pre-existing shareholders, the promoters, the pre-existing investors need to sort out their shareholding in the company. So all of these cases are instances where a shareholders agreement is important. Basically, where the shareholding pattern of the parties, the pre-existing shareholders or pre-existing companies are being restructured or changed, or even newly formed for that matter. So the shareholders agreement is intended to ensure that shareholders are treated fairly and their rights are protected. The agreement includes sections outlining the fair and legitimate pricing of shares, particularly when sold. It also allows shareholders to make decisions about what outside parties may become future shareholders and provides safeguard for minority positions. Shareholder agreements differ from company bylaws. A shareholder agreement is optional. This document is often by and for shareholders outlining certain rights and obligations. It can be most helpful when a corporation has a small number of active shareholders. So yeah, this is when a shareholders agreement is
So
signed.
typically, again, I like to add here, a shareholders agreement is per se binding upon the shareholders and not upon the company. A company is regulated by its bylaws, which are commonly called articles of association. And there has been various judicial pronouncements and cases where the shareholders have signed an agreement and have not incorporated those provisions in the articles of a company. So it has been upheld very clearly. A company is not bound by a shareholders agreement. A company is only bound by the articles. So in case of a dispute, per se, any relationship between the shareholders is governed by the agreement. And if any provision like transfer of shares or has all other rights which Tanya will just be discussing in a short while, all these rights and obligations to be binding upon the company, even the biggest being restrictions on transfer of shares, all these provisions would need to be formulate part of articles. So it is a common mistake. A lot of times we see you do get to sign and execute a shareholders agreement, but the company would not amend the articles to include the relevant provisions of the shareholders and then file the same with the MC or the ROC. Because unless the new set of articles are adopted, they do not become binding upon the company.
Absolutely. Now we're going to discuss the key clauses in shareholders agreement. So like I mentioned earlier, that a shareholders agreement is structured in a way where it covers the major rights and responsibilities of all the parties. So it's very imperative for us to discuss the key clauses in shareholders agreements. Transfer of shares. The shareholders agreement can provide for restriction on transfer of shares in various forms such as preemptive rights, Joffer, drag-along rights, and each of these rights can be exercised collectively or individually. Shareholders agreements must also cater for transfers to balance the desirability that shareholders may be able to divest a decent price against the need to preserve the essence of joint control. So basically, whenever the parties and they sign a shareholders agreement and they're all shareholders of the company, be it majority or minority, any of the party may desire, and obviously they do, to sell their shareholding to a third party outside the company. So whenever this happens, this term is called as transfer of shares. Whenever a shareholder wants to sell his shareholding, his stake, to someone from the outside of the company, a third party, that situation is known as a transfer of shares. So whenever a transfer of share happens, obviously it will affect the other shareholders also if it is not regulated or if it is not captured in terms of the shareholders agreement. And also the shareholders agreement poses restrictions on such a transfer, because if there is free transferability, then there will, like, the company will not be able to hold substance, like it will not be able to smoothly function, because like every second day the person will be freely transferring their shares without any restrictions, without any regulations, and people will keep coming in, replacing the shareholders. That will really hamper and be detrimental to the day-to-day functioning of the company as well. The company will not be able to smoothly function on a daily basis. So transfer of shares also poses restrictions on the shareholder who's selling the shares. This is majorly, of course, it is beneficial to the other party, the non-selling shareholder. This is beneficial to that party, but apart from that, also I think it's a very important provision, because it can protect the integrity of the company, and if the existing shareholders tend to purchase the shareholders of the selling shareholder, then the the thing stays intact. Like the company, it stays intact. It doesn't keep kind of involving third party shareholders. So it's very important to have provisions on transfer of shares in a shareholders agreement.
So again, as Tanya rightly said, it's very imperative to have a very clear clause on the restrictions on transfer of shares, what would be required and what the promoters or the investors envisage, and putting in clear. But again, a shareholders agreement is not in a position or cannot override the provisions of Companies Act. So therefore, a restriction on transfer of shares are usually placed in newer companies or private limited companies. Once a company goes public, these transfer restrictions are not applicable. So typically, a shareholders agreement would have a clause saying that all these restrictions would be envisaged or would be applicable as long as a company is a private limited company. Because the Companies Act very clearly makes a demarcation and states a private limited company is free to impose any restriction on its transfer of shares and amend its articles and so on. But once a company goes public, these restrictions go away, because typically once that's a very common reason, because even a shareholders agreement would have that some of these clauses will move away or be redundant once a company goes public. Because once you involve public and have public at large as shareholders, then it is not in the interest of the company, or the law doesn't provide you to have imposed restrictions on transfer of shares.
We're going to take all the questions towards the end. After our presentation, we're going to give sufficient time for questions, and we're going to take each and every question after the presentation. So I'll request you all to keep your questions till the end of the presentation. Thank you.
No, I think, yeah. So as I already said, the restrictions are not applicable on public companies.
Public listed companies do not have any such restrictions.
Yeah. It's only applicable on private
companies. Absolutely. So the restrictions on transferability of shares are commonly found in shareholder agreements to include a prohibition on transfer without the other shareholder, the incorporation of preemptive rights, giving the shareholders a gift of right of first refusal. One second, please. Yeah. So coming back, the restrictions on transferability of shares are commonly found in shareholders agreement to include a prohibition of transfer without the consent of the shareholder, the incorporation of preemptive rights, giving the non-selling shareholders a right of first refusal. It is neither party's interest that shares be made non-transferable as such. Consent obtaining mechanisms need to be included and various qualifications to consent are required. Time periods need to be included for the service of the relevant notices and the transfers may be prohibited for stated periods only. The identity of the third party purchaser may be the object of the consent and certain categories of permitted transferees are commonly included such as family members of individual ventures or affiliates of corporate shareholders. So basically, like we discussed, and it states that it's neither party's interest that the shares should be made non-transferable as such. Consent obtaining mechanisms need to be included, such as the ROFO and the ROFO, which we're going to talk about next.
Yeah, because I can add just adding to the analogy between companies that allowing private companies to have restrictions and not allowing public companies is for and foremost because companies, especially in its initial formative years, when you have a few 3 or 4 people or an investor coming in, it's very necessary. It's a promoter driven company or it's driven by a few individuals. If those people were to go away and sell shares to an undesirable person or someone other, the whole group, the investors are not comfortable with, or vice versa, so then that may have a big bearing on the working of a company. Because once a company is settled down, is gone public, it's become a large company, then it's run by a management or it's not promoter driven actually. So that restrictions typically, there has been a pretty much, we feel our thought process why the law imposes restrictions on private companies, and which becomes, that's the reason, as Tanya rightly said, it's very necessary for promoters and investors to very clear on the manner in which they would have restrictions on transfer of shares.
Absolutely. So now we're going to discuss the various restrictions on transfer of shares. So the first is right of first offering, which is also known as the ROFO clause. A ROFO provides the non-selling shareholder with the right to be offered the sale shares before a sale of the said sale shares to any third party takes place. So basically, ROFO, like the term suggests, right of first offer. So here what happens that whoever is the selling shareholder, that can be either the investor or any shareholder of the company or the promoter, whoever is selling their stake in the company, they are required to offer that particular sale shares to the existing shareholders and the investors of the company before offering it to any third party outside the company. So here what happens that the terms and conditions of that particular sale are first negotiated with the existing shareholders between the selling shareholders, who are also known as the non-selling shareholders. So there is the terms and conditions, the price of sale, everything is first negotiated between the selling shareholder and the non-selling shareholders in the company before it is even offered to a third party. So here the liability of even determining the price of the share for the first time lies on the non-selling shareholders of the company. So this is known as the ROFO clause. So this gives the non-selling shareholders the first right to either accept or reject the offer of shares on the terms which may be negotiated between the parties. If the offer is refused by the non-selling shareholders, only then can the selling shareholder have the same right to solicit any third party on the same terms that were presented to the non-selling shareholders. So here, the first offer right is given to the non-selling shareholder. If they accept it, that's good. If they reject it, only then the selling shareholder has a right to sell that particular stake to a third party on the similar terms and conditions as were negotiated between the selling shareholder and the non-selling shareholder of the company. The second transfer is the Joffer Clause, which is also called as the right of first refusal. Any shareholder in a company who wishes to sell its shares to a third party, the Joffer Clause places a restriction on such a transfer by either party in terms of the shareholders' agreement by making it mandatory for the selling shareholder and placing him with an obligation to send a written notice to the non-selling shareholders after they have an offer for the sale shares from a third party outside the SHA, giving the non-selling shareholder a right of first refusal to either buy or reject the purchase of the said sale shares by the selling shareholder. So basically, the Joffer Clause, which is also known as the right of first refusal, this is a very popular and a very well-known clause. So what happens in a Joffer? So like I mentioned in Joffer, I'm also going to discuss the difference again after discussing Joffer. In Joffer, what happens that the selling shareholder, again, who can be either an investor, any shareholder, or the promoter, whoever wants to sell their existing stake or sale shares in the company, they will first offer it to a third party, get the price of their shares and a TNC, which has been negotiated or finalized between the selling shareholder and the particular third party. After they have that price and terms and conditions, they are placed with an obligation to present that particular notice in a form of a notice to the existing non-selling shareholders of the company and giving them an offer to either accept that those shares or reject the purchase of those shares on the same terms and conditions as has been negotiated by them between the selling shareholders and the third party. Like it's already the price and the terms and conditions of sale are already finalized. Only the non-selling shareholders in this case are given a notice that this is what we have, this is the price, these are the terms. We are not negotiating. Either you accept it on these terms and conditions, or if you reject it, we are going to make the particular, we're going to go ahead with our sale of the sale shares to the particular third party. So this is what the Joffer Clause is all about.
So now coming as Tanya has just stipulated, two key restrictions are ROFO and ROFR. So, but the main demarcation between ROFO and ROFR, which has to be kept in mind, is ROFR typically gives a right to the non-selling shareholder to first make an offer. So the demarcation is if a non-selling shareholder, so basically it has a huge advantage to the seller. The selling shareholder can typically, can say, the non-selling shareholders will make an offer to him that we would like to buy your shares before the selling shareholders go and solicit to any third parties. So therefore, the selling shareholders here act, the non-selling shareholders has the owners to make an offer, and but in a ROFR, so but in the ROFR it's the other way around, where the non-selling shareholders is under no obligation to make an offer. It is the owners upon the selling shareholder to go and take third-party offers, and once that offer comes, then he will go back to the existing non-selling shareholders or existing shareholders and say, look, I have an offer to that someone is looking to acquire my share at this price. Would you like to buy? And so therefore, it is very essential for anyone getting into a shareholders agreement to use these clauses very judicially and be very clear with the demarcation, because what happens is typically ROFO is usually seen as a clause which favors the sellers, because the sellers will typically get an offer, again now a non-selling shareholder has no price band or a price value. He'll have to get his own valuation done. He'll have to make an offer and say, look, I am willing to buy your shares at X price, and then he's under obligation. If the non-selling shareholder of the selling shareholders agree, he's under an obligation to purchase. So therefore, the owners upon non-shareholder shareholders increase. While in a ROFR, the selling shareholder will go is put to a certain disadvantage, because he'll have to first go get third-party offers and keep the third party waiting, because it may happen he has an offer, but still the non-selling shareholder says, look, I like the offer or like the price, and I'll offer you the same terms. Then he's under an obligation not to sell to the third party, but sell to the non-selling shareholders. So that's the inside, the first step of restrictions come is ROFO and ROFR. And once moving on, if a non-selling shareholder does not exercise ROFO or ROFR, typically ROFR I would say, because ROFO is the offer from his side, then comes the next step of restrictions such as tag along and drag along. And that again, Tanya will discuss in details, the difference and what does tag along and drag along entails. Because typically, I like to stress, tag along is a step post ROFR. So the first step will also be a right of first refusal.
Yeah, absolutely. And I think Sir has clearly told us the demarcation between a ROFO and a ROFO. So just summarizing in one line, I think in ROFO, the sense of responsibility and the obligation is upon the non-selling shareholders of ROFO, where they have to come up with a price. So that is one. And in Joffer, they just have a thing to either accept it or reject it. So I think the obligation in Joffer is much higher on the non-selling shareholders than the Joffer. So I'm just going to mention a few more points about Joffer, which is that the non-selling shareholders get the selling shareholders offer on the exact terms as exhibited by the outside purchaser. This privilege permits non-selling shareholders to gain a control over the sale shares of the selling shareholders of the company, along with the following. The right of first refusal clause, the Joffer clause, provides a cushion to the remaining non-selling partners in a shareholders agreement and to control the process of inducting a new shareholder while the liquidity of the company of the selling shareholders is in control. By this way, the clause provides exerting control to the existing shareholders over the company. In case of a startup fund, by applying Joffer clause, existing shareholders block the inducement of external investor for investment. During the event of any share sale, the same deal being offered to the current interested shareholder to prevent their stock from being depleted. It could provide a fast and hassle-free option to the stakeholder intending to sell that selling shareholder and exit from the business after taking the investment in profit. Joffer provides a balance of power between the stakeholders because it benefits the minority shareholders too. And during the event of stake sale by the majority partner, the interest of minority should not be curtailed. The right of first refusal can be drafted and amended as negotiated between the parties to the agreement and incorporated accordingly as specified by the investor. We've already, I think, discussed the difference between a ROFO versus the Joffer. A Joffer provides the non-selling shareholders with the right to either accept or refuse an offer from a selling shareholder after the selling shareholder has received a third-party offer from its shares. A ROFO provides the non-selling shareholders with the right to make an offer for the selling shareholder's shares before the selling shareholder can solicit for third-party offers for its shares. Joffer is considered to favor those shareholders who intend to stay long-term likely buyers, while a ROFO is seen to favor likely sellers. In a Joffer mechanism, the selling shareholder has to solicit an offer from a third party before offering its shares to the non-selling shareholder. Drag along rights. So the next restriction that we're going to discuss on transfer of shares is the drag along rights. So basically, drag along rights, as the term suggests, dragging something along. Dragging happens in other terms, in normal day-to-day life. It sounds something like, when a person doesn't agree to do something, or it doesn't, something is not working out, so you just drag it along for it to work. Similarly, that is what in the context of a shareholders agreement is also what it means. So a drag along happens when the majority shareholders of a company want to sell 100% of the company to an outside investor, but the minority shareholders of the company may or may not be willing to sell their stake in the company at that point of time. So this happens whenever an external investor or a buyer wants to acquire a company on a 100% basis. So it needs to purchase and buy whole of the company, all of the stake in the company. So when the majority shareholders are willing to sell their stake and the minority shareholders may create an issue by not willing to sell their stake in the company, that is when the drag along rights come into picture, and it creates a form of a security and a cushion for the majority shareholders to drag along the minority shareholders to sell their shares on the same terms and conditions as them, so that the entire company can be acquired 100% to the said buyer.
So typically, drag is something which is prejudicial to the minority shareholder. So it's often very hotly contested or negotiated clause because it gives a cushion. Typically, the purpose of a drag is very simple. If a majority shareholder is, as Tanya rightly said, is selling the control or selling a company, and the sale should not, because typically, and if minority shareholder, someone holding 5% or 10% equity in the company, refuses to sell his shares, and the sale will not go ahead because someone, the new purchaser may require or wish to acquire majority stock or entire stock of a company. So therein the minority shareholders look as a disadvantage because the price is already negotiated and fixed. So he's under an onus or obligation to sell his shares at the price at which the promoters are selling. So he may not be willing, but he's under an obligation to sell. His shares can be dragged and he would simply be required to tender his shares for transfer, and he would be paid the requisite price which is being offered to all shareholders.
Yes, so like Sophie rightly pointed out, this clause particularly can be detrimental for the minority shareholders who may or may not be willing to sell their stake in the company on the given terms and conditions as the majority shareholders are investing. So that's it would be detrimental to the investors.
Yeah, I think someone put a question on. No, see, it would not be operation and mismanagement of minority shareholders for a simple reason: the minority shareholders have agreed. So he's not being forced to offer his shares. He has, in very requisite terms, in terms of a shareholders agreement, has agreed and offered that in case the majority shareholders sell their shares to someone, they would also be willing to sell their shares at the same price, at the same value, and they will not object to it. So a question of operation and mismanagement would only come in a way or a role wherein the minority shareholder did not agree to it. So once you've given a consent to something, you cannot be going back to a judicial system and saying, no, I never agreed, because you already given your consent. Yes, in absence of a consent or in absence of a drag, if or absence of a shareholders agreement, if a majority shareholder is forcing a minority to sell his shares, then it can be constituted as an operation mismanagement, but not in the present case.
Absolutely. I think that takes us back to where we started. What's the purpose of signing a shareholders agreement? All these rights and all the rights and protections provided to all the parties are already pre-decided in the shareholders agreement, and it's signed by both by the respective parties. So whichever rights are being exercised, be it a ROFO, ROFO, drag, tag, whatever, it's all been signed and executed by both the parties. So they do not have an option to later refuse on any of these pointers. And like drag, we're going to talk about tag also, which is beneficial for the investors. So we're going to discuss that after this. So drag along rights in an SHA vests the majority shareholder with the power to override the decision of selling the company and allows the majority shareholder to sell up to 100% of the company. A drag along provision allows the majority shareholders to require the minority shareholders to sell their shares. The aim of drag along rights is to provide liquidity, flexibility, and an easy exit route for a majority shareholder. As many buyers of a target company will want 100% control of the business and rarely agree to allow minority shareholders to retain a minority share, it will be difficult for the majority shareholders to accept an offer if the minority shareholders are uncooperative and block the sale of the company. Drag along rights are triggered in all types of sale transactions, such as merger and acquisitions or a change of control of the company. Drag along rights benefit the majority shareholders counter interest. So yeah, drag along rights are majorly they benefit the majority shareholders and the promoters of the company if they want to sell their company 100%. So yeah. Now comes the tag along rights. So like we discussed about the drag along rights, we also have tag along rights. As the term suggests, tag along. In normal terms, it means when we have a tag for something. So tag along rights in an SHA mean that when the minority shareholders wish to sell their stake at the same terms and conditions as what the majority shareholders are selling their shares, then they have a right to tag their shares along with the majority shareholders to sell their shares along with the majority shareholders on exactly same, not even similar, exactly the same terms and conditions as the majority shareholders. They are also known as post-sale rights, and they benefit the minority shareholders the most. So, like we just spoke about drag, where it's the majority shareholders who are being benefited, they can drag the minority shareholders to sell their shares. In tag, if the minority shareholders wish to sell their shares on a much better, for instance, if they're not getting a better value and they feel that they can benefit more by selling their shares on the same terms and conditions as what the majority shareholders are, then they have an option to tag along their rights also and post and do and come in a post-sale arrangement with the majority shareholders. So that's what is called as the tag along rights.
Yeah. So clearly, as Tanya has rightly explained, the clear demarcation between tag and drag is tag are more known as co-sale rights, which are completely opposite of drag along rights. The tag along gives the minority shareholders the power. They empower them to negotiate the price and negotiate the rights, wherein because typically what will happen is a minority shareholder would not be able to sell his 2% or a 5% stake. So in case a majority shareholder, so typically that comes post offer. So how it helps a minority shareholder is, so assuming a majority shareholder is selling his shares in a company, he would first be under an obligation to make an offer to the non-selling shareholders that would you like to buy my shares. If they refuse, in addition to then obviously the selling shareholder is free to go and sell his shares to a third party. But therein the minority or the non-selling shareholders, if they have a tag along right, they can even piggyback. They can say, okay, fine. You have to ensure that you also sell my shares at the price you are selling. So a great advantage lies or is given to the investors or the people who are able to negotiate a tag along rights. Because again, you have an option of saying yes or no. You may want to tag along, and if you find the price favorable, or you can simply say, no, we would like to not sell the shares, we won't find the price or the term favorable. Whereas drag is completely opposite, where the minority shareholder has no option. He is under an obligation to accept the price at which his shares are being sold. He has no obligation or he has no power to say no.
Absolutely. So I think like drag benefits majority shareholders, tag benefits the minority shareholders of the company. Tag along rights are also known as the post-sale rights and are simply those rights which benefit the minority shareholders. When the promoters or the majority shareholders transfer their shares to incoming investors, the existing minority shareholders can tag along. It means that they can bind the selling shareholders to allow the minority shareholders to sell their shares along with them on the same terms and conditions. Tag-along provisions are usually worded to state that if the tag-along procedures are not followed, then any attempt to buy shares of the company is invalid and would not be registered. More specifically, if the majority shareholders want to sell shares to a third party and do not provide notice to the other shareholders, the tag-along provisions will enable the minority shareholders to tag along with the majority shareholders and sell its shares for the same price and on the same terms and conditions. It's a well-drafted and well-balanced shareholders agreement. When a shareholder wishes to sell its shares, the shareholder is normally required to provide a notice to other shareholders. This requirement is usually contained with a Joffer Clause. Please note that minority shareholder can protect their rights by incorporating this clause in a shareholder agreement, as we already discussed. So difference between a drag along and tag along, like we already discussed, I'll quickly brush up. Tag along or post-sale rights are essentially the opposite of drag along rights, whereas tag along rights give minority shareholders negotiating rights in the event of a sale. Drag along rights force the minority shareholders to accept whatever deal is negotiated by majority shareholders. So here is a balance which is created. If drag favors the majority, tag favors the minority. In some instances, tag-along rights can make the selling process more difficult. It becomes harder to complete the sale when the potential buyer doesn't want to increase or change the terms of their offer in order to please the minority shareholders. Yet, if it is decided and excluded in a shareholders meeting, it has to be enforced.
Can you please be on mute, anyone?
Yeah.
Yeah, carry on.
So, yeah, so here a balance is definitely created. And even like in the second point, if you can see, in some instances, tag-along rights can make the selling process more difficult. It becomes harder to complete the sale when the potential buyer doesn't want to increase or change the terms of their offer in order to please minority shareholders. Even if this is the case and it is executed in the SHA, the tag-along has to be enforced, it has to go through. How hard it may be for the potential investor to either, change their offer or, make it flexible in any way. But if it is signed and executed, it definitely goes through. Fall away threshold. This is one of the key clauses in a shareholders agreement. So basically, fall away threshold, fall away rights, as the name suggests, it means falling away of rights, fall away. So this happens when the shareholding of any party, of any shareholder, falls below a minimum percentage of stake in the company, then certain or maybe all of his rights start falling. That is what this clause means. Why we need to have this clause is because if everyone, say ranging from a shareholder holding of 1% of the company to a shareholder holding of 50% of the company, if they have the similar rights in the company, the it prejudices definitely. We have a question, and the question is that do tag-along rights prejudice the majority shareholders in the event the company has multiple minority shareholders and the investor only seeks to buy the majority shareholders' share?
Yeah, so the answer is yes, because
Definitely.
that's the reason it has to be, as we are discussing, and Tanya has put the demarcation between drag and a tag. A tag is a right which is very, it's not given as a matter of principle or as a matter of. So when a majority shareholder is giving a tag along right, he has to be made aware that his sale will become difficult.
Definitely.
Because yes, but one of the options is it's not necessary to acquire the entire stake of the minority shareholders. So typically, how it would work, if assuming a majority shareholder is selling 40% stake in a company, so he has to ensure that his number of shares being sold reduce, and in the same proportion as he's selling, he has to acquire the shares of the minority shareholders. So very much tag along is a right which puts the majority shareholders, and it's a right usually kept by the investor, because the investors who's putting money in the company at the early stage would like a right, both in terms of tag, where in case the promoters are selling the company, he would like a right to sell. And yes, to answer the question, it does put the promoters at a disadvantage, or the majority shareholders, and usually it's a clause which is very quite negotiated and only given as a last option. Usually in the first course, or the key shareholders would not give a tag along right to every minority shareholder.
Absolutely. Fall away threshold. So like we were discussing about the fall away right. So in this right, like I was mentioning an example. So if there is one person who holds a 5% in the company and one person who holds a 50% in the company, if they both exercise the similar number of rights, then it will become very difficult for the company and its management with regards to the decision-making power in the business, in the company. So we really need to have a clause like this, wherein if a shareholder's stake falls below a minimum percentage, then his rights as a shareholder in that company, whatever he has, will start falling away. So the fall away right, as the name suggests, falling away of the rights of parties in case their shareholding or stake falls below a certain threshold. Fall away right is generally event-based and connected with the shareholding of parties. If there is no fall away right, then even an investor having a minimum stake of say 2% shall have all the rights as that of major investors having 10% stake. And then it becomes difficult for them to operate their business as their decision-making power is hampered. If everyone has the same decision-making power, it's going to be very difficult for a business to run on a day-to-day basis. Fall away right is generally event-based and connected with shareholding of parties. For example, it is seen in term sheets that if investors diluted below 5%, then their right to appoint director on the board of the startup will fall away, or their right of information will fall away. So that is the fall away right.
Yeah, and to again on to what Tanya has said, fall away thresholds become very imperative in terms of what happens is if one of the shareholders is acquiring, let's say, a 15%, 20% stake in a company, he will have certain rights in a company. Vis-a-vis right to appoint director, right to have certain more rights, quorum rights, which we will discuss right now. So what is very imperative for shareholders to agree that when a shareholding reduces beyond a certain manner, the person, as Tanya said, a person that's diluted from 2% from 25% or to 5%, what rights he will still have in a company, what rights he would not exercise in a company. To give an example, a right to appoint nominee director, because it's typically given to someone holding 15-20% stake in a company. It would not be given to someone holding 5%. So generally, even in a way of fall away thresholds, there are thresholds in terms of, if your shareholding moves from this number to this number, certain rights will reduce. And then if it goes beyond a certain level, let's say below 5% or 2%, then probably you will have no rights in the company apart from which a regular shareholder has. Because one of the main concerns is, because what happens is, if in case the shareholder is going below from 25 to 2%, so there is definitely someone who is acquiring his shares. So if those rights have to be given back to the new investor or the new shareholder coming in. So it is very, very crucial and imperative that a fall away threshold be placed or be part of a shareholders agreement, because in every shareholder with he's selling his majority stake to the company cannot be expected to exercise the same rights in the company. So this again becomes a very, very crucial clause and determines the future of a company. Because why I say future of a company? Because if you do not have fall away threshold and you have multiple rights given to a person exercising 2% or a 5% stake in a company, then you would be very discouraging for a new investor to come in. Because a new investor is only encouraged to come in a company if he can exercise certain rights in the company. If he already sees a stumbling block in terms of tag along, drag along, or these rights being given to a shareholder with 1% or director's nominee rights, he would not even like to invest in a company. So therefore, this not only constitutes arrangement between shareholders, but also paves way for future of a company or ensuring how a company raises money in future.
Absolutely. So the next topic that we're going to be talking about, the next key clause, is board meetings. So I'm sure you must be aware of this concept of board meetings. It's a statutory provision under the Companies Act as well. So board meetings, it's a very, like I said, it's a very statutory company law provision. But why we have this in shareholders agreement is because company law is only limited to the extent of having a quorum, which must be 1/3 of the total number of directors, or at least 2 directors should be present at a board meeting. This is the mandate under the company law provision. Why it's necessary to bring this on a shareholders agreement is that who will be on that quorum for that 1/3%? Will both the parties, signing parties, have a say, even if it's a minority shareholder? Will they also have a say in the board meeting? Will they also be a part of the quorum? So all of these to protect their rights with regards to being present in the board meeting or having a nominee director on the board. That's why it's necessary to bring this clause of board meetings in an SHA, because otherwise it is a statutory provision. We did not need to have it here. why we need to have it is to protect the minority shareholders' right, and for them to be sure that they're protected from every side. They can have their nominee director on the quorum as well. So yeah.
So as rightly said, the board meeting concept, the company laws very simply provides in a private limited company 2 directors and in a public company 3 directors who constitutes quorum. But by amendment to articles and by making a provision in the shareholders agreement, the investors or promoters or any shareholder can specify. Again, this is a clause which has to be very thought about, because it says that unless a specific nominee of a shareholder, a director nominee, is part of a quorum, the quorum would not be complete. So therefore, it also, what Tanya rightly said, it gives a huge protection to the shareholders in terms of decisions not being taken in their absence in case they are not coming for a meeting. But having said that, it also ensures delays. So now, in fact, and again, as per Companies Act, you can have if a quorum requirement is not fulfilled, then you will adjourn a meeting. And if at the adjourn meeting also the quorum requirement is not fulfilled, then at the re-adjourn meeting, it will again be 2 directors or 3 if there's a public company. So therefore, law very clearly specifies that you cannot unilaterally or forever keep adjourning a board meeting in case, because that's again a very welcome provision in the Companies Act, and we typically ensure the same also forms part of the shareholders and articles. Because having said that, our investor requires a protection in terms of his nominee being part of a quorum, because in case he is unable to come and attend one meeting, key decisions should not be passed. But having said that, you cannot have a right where an investor would keep on not coming for a meeting and expecting a board meeting never to happen. So therefore, the law provides for the same, and that it is the board meeting and the adjourned meeting. So twice, if any of the nominees who are prescribed under the article forming part of quorum, then it would be any 2 people forming part of a quorum at the re-adjourned meeting. So that ensures quite a balance, that yes, the investors or the minority shareholders have adequate protection, but in case they are being callous and they would not like to come for 2 meetings, the third one they would not be expected, or the quorum rights would not be given to them.
Absolutely. So the board meeting is a formal meeting of an organization's board members, and it's called to discuss the policies of an organization and address the major decisions about future actions. So this is the purpose of board meetings, which we're all already aware of. The quorum of a board meeting must be 1/3 of the total number of directors, or at least 2 directors must be present during a board meeting. The shareholders agreement can provide for specific quorum rights, that's presence of the shareholders nominee to be part of the quorum, and an absence which would not fulfill the quorum requirements. So like so also correctly said, adding on that a shareholders agreement, that's why it's necessary to have this clause in a shareholders agreement, because even the quorum rights, if it has been negotiated and decided that the nominee director has to be part of the quorum, so till there is no presence of the nominee or minority investors nominee director, the quorum will not be complete, and so the board meeting will not be able to go through. So that is a very important protection for the investors. Shareholders meeting. So like board meetings, there are also shareholders meetings. The gathering where shareholders make decisions is called a shareholders meeting, where resolutions are presented to address the corporate concerns and bylaws. The shareholders will learn about the company's activities and vote on the management's proposed resolution, which has been passed or decided in the board meeting. The stockholders have equal say in decisions. A majority of the shareholders must attend a shareholders meeting. The SHA can provide for specific quorum rights, that is the presence of the shareholder to be the part of the quorum, and an absence again would not fulfill the quorum requirements. So like it's imperative for minority shareholders to protect their stake in board meetings, to have a nominee director, and the nominee director plays a very important role in the fulfillment of the quorum as well. Similar rights are also given under the shareholders meeting clause to the minority investors, where again the quorum will not be complete in presence of the particular shareholder as negotiated in the shareholders agreement.
Yeah. So shareholders, as Tanya rightly pointed, you have quorum rights. You can also have in a shareholders meeting. The shareholders meetings also, as per Companies Act, is the same provision as we discussed in a board meeting, whereas two shareholders presence in a private limited company, and we can have specific quorum rights, as again the presence of a particular shareholder would not necessitate or be necessary to form part of quorum. And the same principle as we just discussed, that even if you have a specific shareholder being given right to participate or be part of quorum, he can only block the resolutions, or he can only be part of a quorum. He has to, even if he doesn't come, it's only the shareholders meeting and an adjourned meeting. At a re-adjourned meeting, it would be any two shareholders. So again, what the law ensures that no director or shareholder can in perpetuity or for all times ensure that a meeting doesn't happen.
Absolutely. Moving on. The next topic that we're going to be discussing is reserved matters. So, like the term suggests, reserved matters is also one of the key provisions and key clauses of the shareholders agreement. Reserved matters are generally known as veto or affirmative vote matters. So these are basically the consent matters and a bunch of contractually agreed matters, basically a list of matters which are agreed and negotiated under a shareholders agreement, which need the consent of all the parties before being approved and implemented. It is very necessary to have a list of reserved matters because, again, it's a very important protection for the minority shareholders or the minority investors, that a list of any of those rights which have been negotiated and decided will not be implemented until their consent is also taken to implement those particular reserve matters. So a reserved or veto or affirmative vote matter or consent rights are a bunch of contractually agreed matters provided in a shareholders agreement that need consent of all the partners before being approved and implemented. The reserve matters list is a list of actions which the company and often its subsidiaries must not undertake without special approval by a requisite majority or from specific persons, usually at the board or shareholder level. The reserve matter provisions mandate an additional level of approval above that required by general law. It provides a form of control or protection for those who, with a minority stake, may not be otherwise able to veto or influence decisions on matters if the approval threshold is only that applicable under the general law. So these matters may or may not, under the general law, they can only be decided on by the majority shareholders of the company. But once negotiated and brought in garb of a shareholders agreement, the minority shareholders and minority investors also have a say in the implementation of those particular matters known as reserve matters. It provides a form of control or protection for those with a minority stake who otherwise may not be able to veto or influence a decision as under the general law.
So typically, reserve matters are, because under Companies Act, there is a demarcation, the matters which require ordinary resolution or a special resolution. And a lot of times, there are matters which require special resolution, which implies that 2/3 majority of shareholders need to vote. But many a times in board meetings and at the shareholders meetings, board meeting, of course, does not demarcate between ordinary and special resolutions. And all matters simply require the vote of the present quorum, the majority vote of the present quorum. So which can be especially in terms of so what reserve matters does is, because if a shareholder is holding 5% or a 10% stake or a minority stake in a company, he may be part of a quorum. So quorum only gives him a right to come and attend a meeting. It does not ensure that his voice is heard or he has a veto right over a matter. So what reserve matter does, as Tanya has explained the reserve matters, is it ensures that a lot of times the ordinary resolution matters are moved to special resolution matters, which implies, although it would not entail a filing under ROC as is required for a special resolution, but it entails that majority shareholders or a particular shareholders, a set of shareholders consent is required over these issues. Again, it can become a big deadlock issue or a big issue for a company. So reserve matters list is something which has to be very carefully agreed, because when you are giving one of the shareholders, it may be a minority or a majority shareholder, especially more so to investors, a right to veto a certain decision of a company. So where we are saying where majority of our shareholders would agree, but one investor or a minority shareholder would disagree, still such a resolution would not be passed. That become a, again, a maybe a protection at times, but maybe a big issue, because that means the majority is unable to pass resolutions or carry out business of a company cause one of the minority shareholders has a different view. And this often we've seen as legal counsels leads to huge deadlock situations or dispute issues, because that entails the functioning of a company. Because for example, a simple issue, to give an example, can be future raising of the money, dilution of shareholders. So a minority shareholder who's already holding 5% or 10% may not like the company to raise more money or dilute his shareholding or put more money in a company, while the majority shareholders will be very keen, who are running the operations of a company, to grow and raise money, because on them the impact of a dilution is much lesser. Or various decisions into diversify business, getting into new businesses, how to deploy money to either to raise money by way of equity or debt, or get into some new activities. So wherever you're giving an investor or a shareholder a right to veto over a reserve matter, you have to be very careful, because it gives him the right to block the resolution. And then if he keeps blocking those resolutions, it may impair the growth of a company. Because it is on a positive note, sometimes it is a very good thing, because it's ensuring that the majority shareholders cannot have their own way. They can't dictate the terms and pass any resolution, because a majority shareholder simply said, right, I would like to diversify, I like to raise more money, I like to raise huge amount of debt for the company, and which can lead a company to insolvency, so which is not in the best interest of a company. So that balance is very necessary, and often that balance is not created, because you're giving a shareholder a right, someone holding as low as a 5 or a 10% stake in a company, that he can block resolution. Then where we go? So this is something, as we say, that where the role of our as legal counsels come in, where we do counsel and tell the companies, where they should agree to reserve matters and where they should not.
Absolutely. So the FHA may have a provision wherein certain matters would not be decided without obtaining consent of a particular shareholder or its nominee on board. The same goes a long way in ensuring minority protection rights. Information rights to investors. So information rights provisions in the term sheet outlines the information a company must deliver to investors beyond what state law requires. Generally, this includes a commitment to deliver regular financial statements and a budget to investors. A term sheet's information rights typically terminates in the event of an IPO and often gives investor access to company's facilities and personnel. So basically, investor information rights of a company, it is just to provide the investors with certain information about the company that they are investing into, such as its financial statements and everything on a periodic basis. And it includes to deliver like a mandate for the company to provide this kind of information to the investors. So it's a happily welcome provision for all the investors, since they get the information that they require of the company for the investment, like while they're investing. So moving on. The next concept that we're going to be talking about is the liquidity preference. The liquidation preference is typically defined as a right of the investor to receive its investment amount plus certain agreed percentage of the proceeds in the event of a liquidation of a company, preference over the other shareholders. So basically, what is liquidity preference? So when a company is liquidated in the sense that the company is either sold or the company is basically sold in various events such as the winding up or uh, the sale of the shares of the company or substantial assets or it's acquired. So basically when a company is sold, it's called as a liquidation. The company is liquidated. So what happens when a company is liquidated and it's the time to kind of return the shares and the stake of every person who's invested in the company. This particular clause of liquidity preference, gives the investor who's agreed this clause to get a preference of the returns over all the other investors who are getting that particular return. So what happens is that in a liquidity event, whenever a company is sold, whichever event it is, either it's winding up or it's an acquisition or it's a sale, contrary to the common perception, which liquidity can be in any event, apart from winding up also, liquidation can happen in various other events as well. So when a liquidity event happens, the returns are typically expected to be higher in case of a liquidity event in compared to the winding up. So if you're like voluntary or involuntary winding up when a company is being wound up, the stake or the price of the or buying of that company is comparatively lesser to when that company is getting either acquired or sold when they've reached a particular point that they have to. So definitely the stakes that time are much higher when the liquidity event is something apart from winding up. That is a usual notion. So when that happens, when a liquidity event happens and the company liquidates, that time and when the returns are given, a liquidity preference, like I said, gives a particular investor or a shareholder that preference to get a higher return than the other investors in the company. So I'll give an example here. For example, the liquidation preference can range from either 1x, which is an amount equal to the investment amount to 3x, which is an amount equal to 3 times the investment amount, or in certain instances, even more. So this is a very imperative clause for investors when liquidity happens. So this totally it gives a preference to that particular investor and a much higher one than what he has initially invested into the company.
Yeah, because what, as Tanya explained the concept, the liquidity preference is something insisted by the investors. Because if a company is going to liquidation, they would write a preference vis-a-vis other shareholders in terms of promoters that they should be the first one to be paid. Because as per Companies Act, there is a clear demarcation that all shareholders are on a equal footing, barring preference shareholders. So all equity shareholders are on a equal footing. So what does clause does is it creates an imbalance in terms of or a benefit to the investors, wherein he would say that I would be entitled to a much higher. So unless I am paid a return of investment, the promoters or the majority would not, and whatever is a residual, those would take home. So my return becomes much higher than the return of the majority shareholder. So it is again a minority investor protection where he would get a much higher return on capital than the that of a majority shareholder, because he typically as an investor is a one who put in money in the initial stages, and now that the company is not doing well or is looking at the company is going for a liquidation, he will still require some return on his investment.
Absolutely, absolutely. So the next clause that we're going to be talking about is a non-compete by the promoters. This is it's not any kind of a restriction on the shares transfer. This is a generic restriction on the parties under that agreement. Non-compete clauses protect the exchanging of confidential information. A company should ensure that their information is not being used to set up a rival company by any person with whom the information is shared or for the purpose of sharing such information to a competitor, etc. So non-compete clauses hold utmost importance in business agreements. So this is not only for a shareholders agreement. I think every agreement has and should have necessarily a non-compete, non-solicit clause, which with regards to being a business agreement, because this agreement restricts the shareholder in this context, in the context of an SHA, it restricts the shareholder from sharing the confidential information of a company to any other third party, which can also be a competitor or anything. And so, if they share, this may enable situation of a competitor setting up a rivalry and of course misusing it in any way. So this prevents those kind of a situation. And non-compete provisions, I think, are very, very imperative, even in shareholders agreement and other agreements wherein there's a business relation and confidential information is being shared by the parties. So that is the major importance of a non-compete clause.
Yeah, so non-compete, as Tanya rightly pointed out, has a very key role to play in terms of a shareholders or a joint venture agreement. Specifically because when an investor is putting in money in a company, he would not like the promoter or the majority shareholders to go and start a competing business or provide their key attention to a rival business, because that would hamper the business. So typically how it works is, whenever someone is investing in a company, he needs to ensure that the controlling shareholders would not start a rival business and hamper the interest of a company. Because many a times we see if a company is not doing well or there are some challenges, the promoters will go and start a rival company or start another company with the same business. So that is what is ensured. Then also what non-compete does also plays a vital role where there is a joint venture or a collaboration where the technology is being given by one of the shareholders, because many a time where one of the shareholders is also bringing in some technical know-how or technology. So he will again not like the promoter. So both ways, non-compete works two ways. One is a non-compete during the subsistence of the agreement, which implies that the majority shareholders or the promoters would not do any rival business or competing business during the tenure of the agreement. But even in certain cases, we've seen there are post-termination restrictions. A post-termination restriction implies that even if the shareholders agreement or a joint venture is terminated, post-termination also for a period of 2 years or 3 years, the promoters would be barred from entailing or doing a rival business. So one of the common examples was Hero and Honda, where Hero Honda got into their two-wheeler motorcycle business, and Honda ensured that they could not come into the same business of motorcycles for a period of, I believe it was 3 years cap restriction. So therefore that in a way gives a ensure that the investor or the person who's bringing in technology or the know-how, that if the other shareholders or the promoters were to terminate the company or dissolve the company, they would not have a right to immediately hit the market tomorrow morning, and there would be a time lag of 2 to 3 years where so they would be at a disadvantage. So many a times we see such non-compete clauses are the reason companies are surviving and the companies are not decisions are not taken in haste to close the company or start because the promoters are well aware that if we were to close this business or even if while doing the business or even post termination, we would not be the non-compete clauses applied to us. So this go a pretty long way in protecting the interests of a company, in ensuring that the company does great business, and none of the promoters or one of the shareholders has a right to set up a rival business and probably and so therefore again this is something, while as legal counsel we ensure and advise our clients that it should be well thought through, and both non-compete restrictions at the time of the shareholders agreement being in place and post termination restrictions, because again it's a very debatable issue. Post termination can be reasonable and unreasonable. It can cause hardship to some promoters, as he would not be able to do a rival business or a competing business for certain time post termination. But then these all clauses become very debatable and form part of a formulaic part of the shareholders agreements. And also to add, non-compete is something generally doesn't form part of articles of association. These are clauses per se, restrictions agreed between the shareholders. So even if something like this is not formulated or part of articles, there would be per se be enforceable on the shareholders of a company.
Absolutely. So now we're going to talk about the exit options to the investors. The first exit option is an IPO, which is also called as the initial public offering. An initial public offering refers to the process of offering shares of a private company to the public in a new stock issuance for the first time. An IPO allows a company to raise equity capital from public investors. The transition from a private to a public company can be an important time for private investors to fully realize gains from their investment, as it typically includes a share premium for current private investors. Meanwhile, it also allows public investors to participate in the offering. So it is a preferred mode of an exit option. So basically, typically exit option, like the term suggests, is that when any investor wants to exit from the company, that's called as an exit option. And there are various ways how an investor can exit from the company. That can first be done through an IPO, which is an initial public offering. And this is a process where the shares of a private company are offered to the public in a new stock issuance for the first time. That's how a company gets listed also. That's the IPO process. So it allows a company to raise equity capital then from public investors. Buyback of shares. The exit option of IPO, although a preferred one, is subject to growth in market conditions, and in case of the said IPO not coming through, then in such a case, the other preferred exit option is the buyback of shares of the investors by the company. And in case the company is unable to meet the buyback criteria, then the onus falls upon the promoters. So the buyback at a price which is usually a certain multiple of initial investment by the investor. The buyback at times may include the option to the promoter to identify a strategic investor to acquire equity of the investor.
So coming back to exit options, so as Tanya rightly said, there are various ways of having an exit rights to investor. One and most preferred right is IPO. But again, IPO is something being preferred, but IPO is subject to, as she rightly pointed out, subject to market conditions. Then in case of an IPO not happen, the option comes to buyback. Now buyback, we've generally seen buyback has its own pitfalls in terms of although most of it is a preferred mode of post IPO, because buyback can either be done by a company, again wherein a company has to meet the criteria or the conditions of buyback as envisaged under the Companies Act. And many a times, especially conditions such as lack of free reserves or lack of profitability are some of the key factors which formulate the scheme of a buyback. And if a company is not in a position to meet the criteria specified or envisaged under the Companies Act, it's unable to go ahead with a buyback. Then, if a buyback is not, a company is unable to complete a buyback, the onus falls upon the promoters. So again, it depends very much on the formulation of the clauses, wherein IPO, as Tanya pointed out, is a preferred mode of exit option. Next is a buyback by a company. And in case many a times it is specified that if a company is unable to complete the buyback within a specified time frame, the owners will fall upon the promoters to buy back the investor at an agreed valuation, which is typically a multiple of initial investment. Now, here where the challenge comes is because many a times the promoters, in case a company is not doing too well or is not profitable, do not have the requisite bandwidth or the financial position to fulfill its obligations, and then a promoter may go ahead and look for a strategic investor or a third party to acquire the equity of the investor. And many a cases where, as I said, if a company is not very profitable, is not doing great business, it may not be very easy to find a strategic investor. So that typically leads to a lot of deadlock and disputes, because now we have a situation where an investor has been promised that after a period of 3 years or 4 years or 5 years, he would be given a buyback of shares in case the company does not achieve a IPO. And herein comes a situation where the promoter simply raises his hands and says, neither I am able to find a new investor, nor I have the requisite funds. Then something of consequences, to deal with. There has to be a mechanism to deal with such disputes, because then the company, there are times where we see, an investor also has a right to, seek closure of a company, winding up of a company, and as Tanya rightly discussed, the liquidative preference, seek that the company be wound up and he be given a liquidative preference, because investor, as lawyers to investors or legal counsel to investors, we have to ensure that this is a very common situation. So, and again, many a times it put a company which is not performing at that stage, puts the promoters under tremendous pressure to give an exit to the investors, and also gives a right to the investors to seek liquidation of a company in case they are not able to get an exit. So these are factors, again, something has to be very clearly borne in mind when negotiating a shareholders agreement, because many a times we see the promoters are very keen to raise money and would agree to clauses or agree to stuff which come back to bite them. Again, it's more of a negotiation issue. He would, because the promoters envisages that after 4 years or 5 years, I would be in a position to buy back the promoters, or sorry, the investors, and he doesn't have the funds. So as I said, a provision of buyback should be very well thought through, and also in case a buyback is not achieved, what are the consequences and how the promoters would compensate, or what rights the investor has, should be very clearly specified in the agreement.
Absolutely. The last topic that we're going to be discussing is the termination of the shareholders agreement. The termination clause is also equally imperative as the other clauses. Termination of a shareholders agreement is used when the parties to the shareholders agreement are desirous of terminating the arrangement. There are a variety of reasons for which the parties may want to end their shareholders agreement, but most often the parties will terminate it when a new investment is made in the company, and it's therefore necessary to create a new shareholders agreement. In other words, when a new entity or individual becomes a shareholder by purchasing shares in the company, the existing shareholders may terminate the shareholders agreement by consent and replace it with a new one. Before the new shareholders agreement comes into effect, the shareholders terminate the existing shareholders agreement by deed of termination. The deed of termination of shareholders agreement terminates the contract by consent of the parties. The promoters and investors need to clearly agree and specify the grounds for termination and post-termination events. So I think a termination clause is very necessary in a shareholders agreement because it lists down the reasons and the events of a termination, and it also lays down quite usually a detailed procedure of termination. It gives a particular, it should, and at times it does also give a particular time period, which is also called as the rectification period, that if this particular deed or event is not rectified in this particular time limit, then the agreement shall be terminated, or then it causes an automatic termination. So all of this is listed down in termination clause, which makes it even more important to be well and properly drafted in a shareholders agreement.
Rightly, as Tanya rightly pointed out, termination is something very crucial and very essential. That drafting of a termination clause for us as legal counsels has immense importance, because termination, as Tanya has rightly said, can be for various reasons. So it can be for reasons. So typically, what happens is, in a usual course, if a new shareholder is coming in with a minority stake, he would simply sign a deed of adherence and become part of the company and follow the same terms. But as Tanya pointed out, if someone's coming with a big stake in a company, then that investor would necessitate that the existing arrangement be terminated and a new shareholder agreement be signed. Also, there are situations where it, which needs to be kept in mind. Termination can be for reasons such as which Tanya pointed out, discussed earlier, the concept of fall away threshold. So fall away threshold can be another reason, and also at many a times we've seen termination can also deal with situations of deadlocks and disputes, because you have issues like reserve matters. So if a certain investor keeps blocking a resolution for many a times, and a company goes into a deadlock situation, or our investor is not happy with the company, so therefore it is essential to not only have termination rights, but also deal with post-termination strategy. What happens, if so option of buyback is separate, and one shareholder being given the right to buy out the other shareholder. It also becomes to obviously ensure that the company runs. So in fact, in case of so many a times we've seen situations where shareholders agreement lacks the provisions of a dispute resolution or a deadlock situation. A deadlock situation typically arises and leads to termination. It can be a termination event wherein one of the shareholders, as I gave an example, is constantly blocking resolutions, or constantly the company is unable to function. Then such a way there should be a mechanism where this particular shareholder who has a grievance or who is not very happy with the company should be given an exit option to buy out the blocking, or to buy out the shareholder who is constantly not being because of whom the company is not growing, or the company is constantly blocking resolutions, or is not happy with the decisions of the company. Because in case we have a termination clause and a termination does not deal with a deadlock situation, and how post termination rights of shareholders and how the distribution will happen, that will create quite a uneasy situation. So termination clause apart, as Tanya has run us through the entire presentation, has pointed out various rights, obligations, and how a shareholders agreement would run. The termination gains immense importance, and also the post termination things. This is something, although as we come to almost the end of our presentation, and this is usually we see the even the shareholders and the investors are already burnt out negotiating the key terms like tag, drag, issue of shares, and so on, so forth provision. And termination is actually the last clause to be negotiated. But again, termination is one of the most significant clauses, because it's like shareholders agreement is like a marriage or a relationship where 2 or 3 or 4 shareholders are coming into play and running a company. Now, if one of them was to exit, it may be by natural form of his shareholding falling below a certain threshold, or he not being happy with the company, or there being a deadlock situation. So how do we resolve those issues is all form of termination and post termination rights. So therefore, I would end by saying, it is very crucial that these provisions be very well thought and be envisaged and be put in a shareholders agreement.
Absolutely. So this brings us to the end of this presentation, and I would really like to thank all of you for being with us today. And now the floor is open for any questions.
Yeah. So just to add, I would like to say that Lexfavios, we are a full service law firm, and I head the firm, and I have Tanya with me, who been kind enough to present take the masterclass, and Tanya heads the corporate division of the firm, and typically we as legal counsels advise law of investors and promoters vis-a-vis drafting and negotiating of similar agreements. And if anyone has any questions, we're happy to take any questions now. And please say your name and ask a question, if anyone. I think no one has any questions.
Sure.
Yeah, I think
we have one question.
Yeah, please.
What are the common breaches of a shareholders agreement where the clauses enabling a company to buy back shares at face value possible in the event of breach?
Yes, so common breaches can be anything. A breach is a very wide term. So there is generally a reps and warranties or clauses in an agreement wherein each shareholder has certain obligations to perform, or owners to do certain things. Anyone not doing or performing is a breach. So breaches can be specified. It can be breach of representation, breach of warranties, breach of non-obligations, or but then coming to the second question, which says the clauses enabling buyback at a face value. Absolutely. So again, as we said, and Tanya also pointed out, that shareholders agreement is all about a mutual agreement between shareholders. So once you agree, that the buyback would be at the face value, it is per se enforceable. If you agreed that the buyback would be like a multiple, 3 multiple or a 4x or a 3x, then that be the case. So now once the shareholders has agreed that I am happy that my investment or equity be bought back at a face value, then it is per se enforceable. But on a practical note, it is very, very unlikely that anyone would say that I have been an investor in a company for 3 years, 4 years, or 5 years, and now I'm happy to buy back and sell my equity at the same price at which I came in. Practically, that doesn't work. But theoretically, to answer your question, yes, if you agreed to something. So as I said in the first go in the beginning of my presentation, shareholders agreement is an agreement which is not typically defined in law, and it's an optional agreement. When I say optional, when you buy a house, you need to have a sale deed. When you take a premises on lease, you have a lease agreement. You transfer a technology, you have a technology agreement. But to run a company, you don't require a shareholders agreement. A company is per se governed by the articles. So once our shareholders come and 4 or 5 shareholders or 3 shareholders and collectively start running a company, it is a completely optional thing for a shareholders to act, but as a matter of great practice, to put on place a shareholders agreement. But once they have put in place an agreement, agreed to certain obligations, and as Tanya just explained us the entire stuff of what goes into an agreement and various provisions, each of these provisions becomes enforceable. And even in case the company has failed to incorporate the provision of shareholders into the articles, so then issues like transferability or certain rights, quorum rights are per se not enforceable. But again, any provision inter se between, let's say, a non-compete or inter se any rights between the shareholders are still enforceable. There have been various judicial pronouncements and where it's been challenged that shareholders agreement is not enforceable. But it is not enforceable against a company, but it is enforceable against the shareholders of a company, because shareholders have come and mutually agreed. It may be, so again, there where comes the issue that it has to be carefully drafted, and each person signing, he should not blindly be signing and saying, yes, I'm agreeable to it. Because once he agrees to a clause, it may be a transfer of shares, a buyback, or a drag. How much it puts a shareholders to a disadvantage. It is per se enforceable against him. He cannot turn around and say, I was not aware of the consequences and I just signed an agreement. So each and every line and every clause, once executed, that is the reason we also have a provision of a deed of adherence, that if a new shareholder comes in and he's not a majority shareholder, so the existing shareholders need to ensure that he signs a deed of adherence or a document saying, I am bound by a new shareholder. So typically, there would be a provision in a shareholders agreement where a new shareholder, let's say someone coming in with 2% or a 5% equity, the company may say, fine, we are not giving you any new rights, you just have to sign up, because it's not possible for each time a minority shareholder comes to sign a new agreement. So if he signs a deed of adherence, it is as great as signing or being a signatory to the main agreement, and it is bound upon him. So every obligation. We have seen many situations where the matters have gone, in disputes, and each and every time it has been upheld that shareholders once agree to certain provisions, he cannot wriggle out of his contract.
Absolutely.
Do we have any more questions for anyone?
We have one more question.
Yeah.
Which is more beneficial right to me as an investor, ROFO or ROFO?
See, again, ROFO has, so when you are a seller, ROFO is more favorable.
Exactly. It's more than an investor promoter perspective, it's more of a seller buyer perspective.
Absolutely. Because we need to understand the demarcation. What is ROFO doing is, ROFO is saying, me as a non-selling shareholder have to go and make a offer.
Yes.
It is my prerogative where I would take the first step and the lead and go to the shareholder saying, please sell me your shares at a certain price. So therefore, the selling shareholder, is under a boundary obligation to either say, I accept your price and I'll sell you the shares, or he can simply say, I don't agree to this price and I will not sell you the shares. And then he's put at a particular where he cannot sell to anyone else at the same price. But so again, it's a seller advantage, because seller can simply say, okay, fine, I want to, yeah, because seller is because whereas comes to, why do I say it's a seller advantage? Because in a offer you have a more complicated procedure. Because the selling shareholder will first go to the market, pick up offers, get someone to, and it's a very difficult situation where you are getting someone to invest in your company, but saying, look, I will only sell you my shareholders if my other shareholders do not buy. So he is put at a disadvantage, because here he is first going to the market, getting some offers. Now the challenge becomes is the offer he is getting is much lower, or is not the desired offer or a price, and he's done. And also the third party is not making a very great offer, because he knows he's bound under an offer clause. And whenever an offer comes, he will go back to the non-selling shareholders who are put at an advantage and say, look, I have an offer, would you like to buy? And only in the case of a non-selling shareholders refusing to buy, he can go and sell to a third party. And if the non-selling shareholders find the price very attractive, that he has not got a very great offer, so they will say, fine, let's buy your share at this price. So there is no right or wrong, but it's a question of what suits you.
Do we have any more questions? Okay, so I think there are no more questions.
Yeah. So thanks everyone.
Thank you so much for joining. Yeah, and I would really like to thank Mr. Sumesh Dewan for giving such a nice presentation.
Likewise, Tanya, for being spearheading the masterclass, and thanks to you, Tanya, for giving your valuable inputs and sharing the whole structure of a shareholders agreement. We will shortly be putting this presentation on Lexfavios website and the entire webinar, and anyone can reach out to us or to me or Tanya for any future questions.
Yes.
Our contact details are available on our website, and please feel free to reach out to Tanya, who heads the corporate practice for our firm. Thanks everyone.
Thank you so much. Thank you.